There were a number of motions filed in the Sarah Boone case, and we know that trial is quickly approaching. October 7th is the start date, so only a few more hearings possibly before the actual trial is going to commence. And like this judge has said, there is not going to be any sort of adjournments, any continuances. This trial is absolutely going on October 7th. But there were a number of very important motions that were filed. We explained one of the motions, but there were a number of motions that were argued in a hearing yesterday on September 19th, 1:30 p.m. If you were able to join us for the live stream where we live streamed it and we actually provided some live commentary on that, then that's great. If you're not able to sit down and watch that, well, this is going to recap everything that happened in that hearing yesterday. And the most important, without a question, the most important motion that was argued yesterday was the state's motion to strike the defense's notice of intent to rely on battered spouse syndrome as a defense. And we're going to explain all of that a little bit more in detail as the video continues. But there are some other motions that went on first, and also some interesting issues that were brought up before that motion. So let's talk about those first, and then we'll get into the actual meat. The main part of yesterday's hearing was with regard to the battered spouse syndrome defense. So first, let's talk about the motion for a statement of particulars. Here, the defendant asked that even though technically the state did follow the statute and the rules of criminal procedure in Florida to give notice to Sarah Boone about what she's being charged with, but the defense wanted much more of the particulars of exactly what they're charging, why, every detail. They wanted much more detail in the charging documents. Now, generally speaking, in an ordinary case, you don't get that. The state can comply with the statute by just simply laying out the very basic bare bones of the charge. But there are extraordinary cases in which that is allowed. So here the defense is moving that this should be considered an extraordinary case, and therefore we should get a particular charging statement, much more of a particulars for what they're charging Sarah Boone with. And on that motion was denied. Then there was a motion for additional discovery. What type of discovery can the defense possibly want at this point? There's already been voluminous discovery documents that were turned over. So what more discovery do they want? Well, this is what they want. They wanted the policies and procedures when it comes to interrogating or interviewing witnesses. And this is a policy that the Orange County Sheriff should have. And that's what they want. They want the policy of the Orange County Sheriff's Office for how they conduct investigations and interrogations specifically, and interviews. Why is that? Well, one of the arguments that the defense wants to make, and probably a motion that we're going to hear soon. So he didn't say he filed it yet, but most likely he gave us a little bit of a hint that this motion is going to be coming down. And that is that they're going to argue that the Miranda rights were not properly read to Sarah Boone. And therefore, if her Miranda rights weren't properly read and she didn't really give any consent and understanding to what was required under the law, well, then anything that she said in that interview or interrogation, whatever you want to call it, should not be allowed in. So that's going to be a very important issue. So the defense is going to argue that some of the Miranda rights or some portion of it was not properly read. And therefore, they want two things. They want the actual card in which one of the officers read the Miranda rights, which was the representation at this point that she just read it off a card. And if that was read off a card, they want to see that card. And they also want to see the policies and procedures when they go ahead and interview witnesses. So the response to this was, by the state, that who cares what the policies and procedures of this Orange County Sheriff's Office is? It doesn't really matter. This is a constitutional issue. So you heard the recording. You've got everything on tape. You got everything recorded. If that does not comply with the constitutional protections that Sarah Boone has, so then you can go ahead and move to strike portions of her interview or whatever you want to do under the law. You can do that. There's no reason for you to actually have the card or to have any policies. Who cares about the policies? Our policy is the Constitution and the Constitution of the state of Florida. So that's all you need. You don't need anything more. You've got the interview. You've got the interrogation. You got everything on video. Go look at that. If you feel that something was done wrong, then file a motion. You don't need the actual card that you read from. And the judge agreed with the state, and he denied this motion as well. There was also some motions to appoint a forensic psychologist. There's a number of motions to appoint different experts, and they were all essentially granted. And also the motion for costs, that since Sarah Boone is indigent, so the defense should not have to pay for this out of their pocket. So those motions were granted as well. And there's certain ways that they reimburse these witnesses, and they're only limited to a certain amount. And if you want more, you have to go file more papers. Okay, but this is really just nitty-gritty details about exactly how to get your costs reimbursed. So that was some of the motions as well. And there was also then a motion for the return of property, which is Sarah Boone's cell phone that was extracted by the state. So the defense really also wants to extract the phone. So really, of course, they're not going to return the property. They're not going to return her phone to her, but they just want their expert to be able to extract the phone using his expertise and be able for their expert, for the defense's expert, to analyze whatever was on her phone and maybe somehow contradict something that the state's expert who looked at her phone is going to say. So that's what they want to do as well. And that was granted in those respects. So obviously it was denied in the way that he was asking that the property should be returned, but it was granted that, of course, his expert can have access to her phone and download what is necessary. There's also a motion for the enlargement of time, and this is where he's arguing that I just got involved in the case late. I need some more time for some of these deadlines that you set. And with respect to objecting specifically to the state's evidence, that was granted. But that was only extended a little bit. I think it was to September 26th. So then he has a few more days to look over the exhibits and the evidence that the state proposes to admit during the trial and lodge his objections now. So that was allowed, that he can have a little bit of extended time, but nothing more than that. Okay, now let's get into the actual motion, which was really the most important part of the day. And that was this motion to strike the defendant's notice of intent to rely on battered spouse syndrome. So just to understand, in Florida, you can't just show up to trial first day and start arguing to the jury that your defendant, your client, the defendant in this case would be Sarah Boone, is the victim of she was a battered spouse. And therefore, because she's a battered spouse syndrome, so therefore we can call these experts and explain why she felt in danger the way that she did. Okay, so you can't do that. In Florida, you have to give at least 30 days notice. You have to file a notice of intent. And in that notice of intent, you have to be particular why you believe that the battered spouse syndrome defense applies in your case. So initially, within 30 days before, which was completely fine under the rules, 30 days before, the defense did file a notice of intent to rely on the battered spouse syndrome defense. And it was very, very bare bones. It was just essentially, we have one expert, Dr. Julie Harper, who's a forensic psychologist, who did examine Sarah Boone, did speak to her, and is going to conclude that she did suffer from battered spouse syndrome. And that's essentially all that they said. That was very limited notice. And then with another week or two passed, they filed an amended notice of intent. And again, I thought that the state may bring out the point that that amended notice is not within the time period. It's closer to the trial date, and the notice has to be given at least 30 days before the trial. So the first notice, you're right, but the second amended notice, that should be stricken because it's just not timely. But they didn't make this argument. They argued much more on the substance and the merits of whether Sarah Boone can actually argue the battered spouse syndrome. So let's first a little bit understand how battered spouse syndrome defense works. Okay, so there's a case called U.S. versus Barnes. U.S. versus Barnes explains a little bit about battered spouse syndrome. This is what it says. Battered spouse syndrome is a set of psychological and behavioral reactions exhibited by victims of severe, long-term domestic, physical, and emotional abuse. It is not a mental disease or defect. Rather, it is a post-traumatic stress disorder. So in the mental health world, that means a lot, whether this is a mental disease or defect, or whether this is considered PTSD, post-traumatic stress disorder, that this woman who is a battered spouse suffers from. And this is also part of what the argument for the state was, that there's no evidence that this is a person who was suffering long-term domestic, physical, and emotional abuse. Yes, she got drunk, and her boyfriend would get drunk, and they would have some problems therefore, but this is not someone who otherwise would have some sort of reason to argue that she has a history of domestic, physical, and emotional abuse. That's number one that they were arguing. But let's continue with understanding what battered spouse syndrome is. So this is very important to understand. It's a nuance, but this is something that's important to understand, which you're probably not going to be explained on any other channel. So listen carefully. Battered spouse syndrome is not itself a legal defense. And what does that mean? That means that you can't just argue to the jury, this is a woman that suffers from battered spouse syndrome. And that's all the determination that you have to make, whether she suffers from this or not. And if you find that she suffers from it, then you can excuse everything that she did. That's not the way this works. You can't just say, we have our experts, they have their experts. Which expert are you going to believe? Whichever expert you believe, then your verdict is going to have to be either guilty, if you believe with the state's experts that she doesn't have battered spouse syndrome, or that if once you believe our experts that she did have battered spouse syndrome, then that automatically makes her not guilty. That's not the way it works. Okay, and this is in the case called State versus Hickson, which is the beginning of battered spouse syndrome, where that becomes a recognizable theory that you can argue in Florida. And this is what it says. Again, battered spouse syndrome is not itself a legal defense. Well, what is it then? But it's evidence that the defendant suffers from battered spouse syndrome, and then that's admissible to support a claim of self-defense. So when you have someone who is charged with murder and you want support to argue that she acted in self-defense, you can bring evidence that she was a battered spouse and that she suffered from battered spouse syndrome in order to support her ultimate claim that this was her acting in self-defense. So still, this is really your argument, your defense here is really self-defense. That's the defense here. So when you argue to the jury, your case, when you're the defense attorney, you have to argue, ladies and gentlemen, this is a case of self-defense. Now you're going to be hearing evidence that she was a battered spouse syndrome, that she suffered from battered spouse syndrome, and that she was a battered spouse. And therefore, that's why we can understand why she acted in self-defense. But ultimately, this was a case of self-defense. And to explain this a little bit better, a little bit more, there's another case. And this is what this case says. The introduction, and this is called Oquenda versus State. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality. So it's not here. Battered spouse syndrome is not here to explain to the jury that this woman had her own reality. You know, we hear about your own truth. So it's not to prove that she had her own truth and felt threatened when her husband came home or her spouse came home or her boyfriend came home and said, hey, how you doing? And she felt threatened and therefore she killed him. That's not what this is about. You can't say, well, in that case, she suffered from battered spouse syndrome. And therefore, even though he just walked in the door and said, hey, how was your day? And she felt threatened by that and therefore shot him. That's not the way this works. That's not to go into her mind to say, oh, that's how she felt at that moment. And therefore she was justified in shooting. No, it doesn't work like that. So let's explain a little bit more what this means. Again, the introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. That's not what this is. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable, to show, in spite of a reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. So it really, again, it all comes down to, was she actually in a situation of imminent death or great bodily harm? Now, as the jury, you may be thinking, what is wrong with you, woman? You've been being abused by this man for the past 20 years. Why would you stay with him? And if you stayed with him, then maybe you deserve what's coming to you if you would make such an irrational decision. So to take care of that problem that the jury may have, you can introduce battered spouse syndrome. And you can explain why a spouse or girlfriend would stay in that relationship, even though it's going down the road of putting herself into eventual imminent death or great bodily harm. And if the jury buys that, then they can say, okay, at this point of time, she did feel that her life was in danger, and she was in danger of imminent death or great bodily harm, and that's why she acted that way. Okay, so that's how the battered spouse syndrome works. All right, so now that we have a little bit of understanding of how this works, let's move into the next part of this. The next part of this is a case called Wagner versus State. And if you were watching the proceedings, you're watching the hearing, you heard the judge talk about Wagner versus State, and he kept talking about this case. So what do you think we should do if we really want to understand what's going on in court? Should we just talk about it like we pretend that we know what we're talking about? Should we call someone from Florida and ask them what this case of Wagner versus State is? Or what we should do is, so it's not a lazy way to do it, but what we should do is actually look up the case and see what the case talks about, and then we can have an understanding of what the judge was talking about and what the response was. All right, so what is the case of Wagner versus State? Wagner versus State, I looked it up, and the case was the following. The facts were that there was a couple, obviously, in a relationship, and they did not have the greatest relationship. And at some point, the woman in that case left the husband and eventually came back to the house, and she pulled out a gun. And she wanted her keys. She wanted something from the husband. The husband threw her the keys, and then he walked to go back inside the house. Somehow, when he walked to go back inside the house, her gun went off and shot him in the back. Now, he didn't die, but she was charged with attempted first-degree murder. Someone shot in the back. That's pretty awful. And in that case, what happened was that the defense argued that, and the court actually makes a point of saying that he argued at least 15 times in his closing argument that this was an accident. The gun went off by accident. And then eventually he appealed. He lost the case. The defendant lost the case. And then they appealed because evidence of battered spouse syndrome was not allowed to be admitted into that case. So again, the essential argument there was that this gun went off by accident. It wasn't because she felt that her life was in danger. It wasn't because she had an imminent fear of death. It was that it went off and it was an accident. Somehow it just went off and shot him in the back. So in that case, Wagner versus State said, if your argument is accident, then there should be no evidence of battered spouse syndrome allowed in. And this is what the case says. Appellant has not cited, in this case, appellant means defendant, because it's just a way that they refer to them on appeal. Appellant has not cited, nor has our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense. And if you think about it, that makes a lot of sense. Why should you be allowed to bring in evidence of battered spouse syndrome if your whole argument here is that it just went off by accident? This was an accident. This whole thing was just one terrible accident. What does battered spouse syndrome have any sort of relevance to that? Well, listen to this. Because they do bring one jurisdiction. Again, this is Florida talking about a different jurisdiction. And this is the jurisdiction of West Virginia. And listen to this. This is a very interesting mental exercise for all of you. The only contrary authority appears to be State versus Stewart, in which a sharply divided West Virginia Supreme Court held that the admission of battered spouse syndrome evidence is not limited to cases in which the defendant claims self-defense. So the question that the Florida Supreme Court was dealing with in Wagner versus State was, is there any sort of relevance to bringing in evidence of battered spouse syndrome when the entire argument is accident? So they do bring this West Virginia Supreme Court case, which did hold that it's admissible. And listen why. Because such evidence can also be used to show that the defendant could not have formed the intent necessary to commit the crime. And this is what they quote the case in Virginia. They're quoting a case now directly for this case, State versus Stewart. This is a direct quote from that opinion. Battered spouse syndrome is admissible to explain to the jury how domestic abuse may affect a defendant's reasoning, beliefs, perceptions, or behavior. At the end of the day, this is affecting your reasoning, your beliefs, your perceptions, your behavior, the fact that you suffer from battered spouse syndrome. So that could be relevant, even if it's not going to prove to you the ultimate conclusion or the ultimate argument that you were arguing, that you were defending yourself. You acted in self-defense. Nevertheless, it still does show who this person is. And because you're so affected by this condition, it can affect your reasoning, belief, and it can affect any intent that is required for the prosecution to show or prove that you had some sort of intent when you acted this way. This evidence is relevant because it may negate an essential element of the crime charged, such as premeditation, malice, or intent. So very interesting how the West Virginia Supreme Court deals with, and again, this is the law in West Virginia, that sometimes you could have some evidence of battered spouse syndrome, even though you're arguing accident. So the question is going to be, well, what does Florida do? And this is what they say very clearly. However, this type of diminished capacity evidence is not admissible in Florida. So in Florida, it's not admissible. So at the end of the day, if you're arguing mistake, if you're arguing this was an accident, then you cannot, there's no reason why battered spouse syndrome should come in at all. No evidence, no experts, nothing can come in with regards to battered spouse syndrome. So what is this case? Is this a case of an accident, or is this a case of self-defense? That's the ultimate question we have to determine. That's what the judge has to decide before allowing battered spouse syndrome evidence to come in. So this is what is stated in the state's response, because the state filed another motion to strike the defendant's amended notice. So this is what they say here. They're arguing that this is all mistake. And how do we know that this argument, this defense is all mistake? Well, they quote the interview that Sarah Boone gave with law enforcement. And listen to how many instances they quote here. Number one, when asked about the decedent's other injuries, this is what she said. In all honesty, we have never gotten into it. B, the defendant said that she and the decedent were having a good time on Sunday, having wine, painting, doing puzzles, and listening to music. Nobody laid a hand on nobody. Well, very clearly, she did not seem that she had any sort of fear of imminent danger. Continuing, I have not touched him. We had a good day. It was a good day. We've had good days lately. So it was a good day. Everything was great. She didn't say that all of a sudden he turned into a different person. There was no ill will between us last night. Last argument was maybe last week. These are all statements that she gave to the police. I was so happy, like it was such a good day. I kid you not. Nobody touched nobody. Nobody touched nobody. Again, it's the drinking. That's what it is. It's the drinking. I thought he was okay. I thought he was okay. Sounds like it's an accident, a mistake. Again, everything was fine and dandy. Here's the question. Why didn't you just let him out of the suitcase? Answer, to be honest with you, I don't know. Here we go again. I will never drink alcohol again, showing that this is all just an alcohol mistake that she made. Again, what was your motivation for leaving him in the bag? Answer, I didn't have any motivation. It was me. He and I was having a great time, great day, fooling around and being stupid. And apparently me going upstairs and going, I'm blaming it on the wine. Again, she's all blaming it on the wine, on the alcohol. Again, question, you two didn't lay hands on each other? Answer, no. Again, I don't have any injuries. He and I have not been at it with one another. Again, she didn't do this intentionally. Alcohol is a bad thing. And I'm changing what she actually said. And again, another statement. So it's like, okay, so while we're in a good place right now, I'm going to snap. Is that what while we're in a good place right now? So again, showing that she's in a good place. Seeing that's the thing too, but you can clearly tell that I'd been drinking some. I didn't touch him, nor did he touch me. So very clearly, she's telling the police This wasn't a case of self-defense. This is a case of too much alcohol, and I don't know what I was thinking. I just left him in there, assuming he's going to be fine, assuming it's a bad joke, and that's what this is all about. So, very clearly from her statements, this is an accident. This is what the argument should be. So this is what the judge was asking the defense attorney, saying, well, if this is all accident, so then how can we allow your expert to come and testify about battered spouse syndrome? How can we allow you to argue to the jury battered spouse syndrome? How can we allow this in at all? In fact, maybe it'll even be reversible error now that we have the Wagner case, which says clearly it's not admissible. So this is where we have to show you just a small clip from what happened. And here we go.
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you...
So there you go. The judge is just shocked. Wait, is this self-defense or accident? Oh, wait, this is self-defense? Now you're arguing that this is actually self-defense? And this isn't an accident? This isn't a mistake? So you're changing your whole theory of the case. The case is not an accident anymore. Now the case is self-defense. Well, if your case is self-defense, then, okay, then there's reason to allow battered spouse syndrome evidence in. But the question is going to be, the ultimate question is going to be that the judge took this under advisement. He did not make a ruling at the time. And the judge said he's going to write opinion about it. But now what the judge has to think about in his chambers is, are all these statements that she gave to the police, do all those statements mean that she is locked into the position of accident? Now remember, in that other case, the case was tried and the defense used multiple times, or they argued in closing arguments that this was an accident. Here the question is going to be, even though she made all those statements to the police, where it seemed pretty clearly that this was not an argument, this wasn't something that was escalating, this wasn't something that she felt in imminent danger of, this is just a mistake, this is just too much alcohol, are all those statements that she gave to the police, does that mean that now they are precluded from arguing now battered spouse syndrome, and they are precluded from bringing any sort of evidence of that in? That's what the judge has to make a decision about right now. And remember, the defense is going to file a motion to strike some of her interview that she gave because of the Miranda issue. So if you completely strike all of her statements and you're back to the drawing board without her statements, well, then there's no evidence that she was arguing that this was a mistake because all her statements are out. And then they'd have a much easier time. Again, not an easier time, but it's still, they can at least get into the door to argue battered spouse syndrome. Now, I know a lot of people aren't buying this, but the question really here is more technical, more legal, whether they're actually able to make the argument to the jury of battered spouse. So that's what the judge has to make a decision about right now. That's really what's going through his mind. He's probably doing some research, what the extent of the evidence of accident has to be in order to preclude battered spouse syndrome. This is probably what we're going to see in his opinion, which is going to be coming out. Well, that is a recap of what happened during this important hearing. And as the opinion comes out, I'm going to look through it. And like always, I'm going to research, look at some of the cases that the judge cites and see whether I agree with his opinion or not. But that's what we're waiting on right now. And it's going to happen pretty soon. Probably not today, but maybe today, maybe next week sometime, most likely. So that's what we have to look forward to in terms of this specific motion. Because again, if they don't get in the battered spouse syndrome, then they're stuck with that this is just one big mistake. And that's what the defense is going to have to be. So an interesting twist and turn in the Sarah Boone case. So we'll see what happens with the opinion. Of course, we're going to be there to cover it. I am thinking about, by the way, live streaming this trial also. So we're going to still consider that. If you want me to do that, leave a comment letting me know that that's something that you'd like. We did already live stream the hearing. If you want to see what that's like with my commentary, check that out and see whether you want to join us for the actual trial of Sarah Boone as well. So that's going to be it for now. Please, if you haven't, subscribe, like the video, and we will see you next time.